Hello, I'm Carla Wheeler. This is for Project Management 693 with Dr. Gonzalez, Park University, Unit 6. And today we are discussing the importance of contracts within an organization, and along with contracts, talking about breaching, damages and remedies, and ultimately just the entire contracting process. So contracts can be very complex depending on the type of organization. Sometimes an organization has different types of business issues, which will make a contract more complex opposed to more simple. They may have tax issues, reserve rights, different assets, multiple companies involved. Those are all the things that make a contract more complex. However, contracts are important because they outline the expectations and the requirements of both parties. Now, when one of those parties fail to perform the obligations, and this is called a breach of the contract. And when you have a breach of the contract, sometimes you can end up in court, with litigation, but normally two parties will try to negotiate and settle without going to court. But if you do end up going to court, there are damages and remedies that the courts, reward to the parties as a result of, of the breach of the contract. Some of the damages that are mentioned, can be monetary. Some of them can be liquidated, and another category of damages is nominal, meaning very small, if nothing at all. Some of the remedies that are important in court systems is, specific performance, where the pretty much a judge will, require the party that breached the contract to fulfill their end of the agreement. There may be a part where recession may take place, where the courts just undo the contract and act as if it never existed, or there may be restitutionary damages, and where the party is compensated for what it is that they have paid. So it's always very important to understand what type of agreement you are entering into, as well as the type of as well as the company that you are doing business with. This will let you know if your agreement is going to be simple or more complex. And then, like I said, just understanding the entire contract process. Understanding. You may hear that there are 5 steps. I've heard up to 7 as far as the entire contract process. But basically, you start off with the planning and implementing stages, which is pretty much the contract creation, the negotiation phase, where which can be time consuming, and a lot of back and forth between the parties, but it's very important to outline any deal breakers within the negotiation process. You kind of go into the pre-contract phase, or with the awarding, where terms and conditions are approved, documents are signed, and on to the final stages, the contract stage, where the contract is actually executed. You go into a more monitoring phase, making sure that the agreements are upheld, and then finally the closeout and renewal, where the contract has ended, and at the time you can determine to renew the agreement or start another process. Thank you.